Welcome to the Brighteye Edtech Startup Festival. Thanks for joining. Thanks for your support. It's great to see you all. And today we have been diving into international expansion with 2 sessions earlier, all recorded and will be shared, covering the big decisions of when and where, and looking at the actual execution of move into new markets. Today, and right now, we also have our first bonus session of the week, a legal Ask Me Anything with Matt Johnson from Cooley. I'll let Matt introduce himself a bit more fully in a moment. For now, I'll introduce myself. I'm Hege, and I'm head of community at Brighteye Ventures. We are the most active EdTech-focused VC in Europe, with interests spanning the sector from early years to lifelong learning and everything in between. We partner with companies across Europe and in your early stages, supporting you in pre-seed, seed, and Series A, with both investment and thematic support, where we think we can be most helpful. And that's how we got the inspiration to create a festival like this from some of the work that we've been doing with a lot of you guys. So we're proud to present some of the best experts in the industry, contributing this week with their knowledge and experience on a number of topics relevant to building and growing your startups. So for this session in particular, we hope there'll be some helpful conversations and connections made by all of you. And please feel free to start getting your legal questions coming in the chat and raise your hands, and we'll get you on stage to ask Matt the questions. Which brings me on to here and now. Let's bring on the legal Ask Me Anything. And the me in this situation is Matt, not me. So it's great to have you here, Matt. Welcome.
Thank you. Thanks for having me, and thanks to everyone for joining this session. I'll just do a brief introduction of myself and Cooley, and then kind of give some thoughts about how this could work, but intend this to be very informal and very sort of much just a conversation. We can sort of play it by ear. I don't really have any set agenda or set of topics that we need to talk about, but some ideas if they can serve as a way to jumpstart the conversation. So my name is Matt Johnson, and I'm an attorney at Cooley LLP. So Cooley is a global law firm. We're headquartered in Silicon Valley. We have 17 offices around the world. 2 of which are in Europe. We have 1 in London and another office in Brussels. And then we have a number of offices throughout East and Southeast Asia as well, and then in the United States. And we are a tech and high growth company focused firm. I would say the bulk of our clients are venture backed or companies that are looking to go the venture capital route for growth across a variety of sectors. One of the things that what Cooley does that's a bit unique for law firms is that we have practice verticals where you'll have attorneys that are focused on sort of just representing companies in a sector that we feel very strongly about. We've done that across a number of sectors, and I am part of Cooley's education and EdTech practice. We define that, quite broadly. Pretty much any company or investor that's touching on, the future of learning or the learning economy of any type at early, from early childhood up through workforce and lifelong learning, we consider part of that. But I do just focus on companies that are operating in that space, from very early stage pre-seed companies up through large public companies and sort of every stage in between there. The way we structure it, the reason we structure it this way is to allow us to try to provide more practical and actionable guidance for companies, help them sort of figure out what's most important to be focused on, depending on who their customer is, what markets they're operating in, what stage they're at, and kind of try to factor in all of those and apply some sort of real world intel into that. But I guess the counter to that is that I'm certainly not myself a legal expert at every potential issue that a company could be facing. So certainly feel free to ask any questions, and I may have to say that's not my area of expertise, and can always, if there's something that I can't talk about here, certainly happy to connect you with someone who can. The good thing about sort of the Cooley network and infrastructure is if there is a, technical question in some area that I'm not an expert at, chances are we have someone else who is. I guess that's one qualification I need to give, is that I may not be able to answer every question, even though it's ask me anything. We'll do my best to answer as many of them as I can. And then the second part of it is that, and this is the usual sort of lawyer caveat, that this session is for, educational, informational purposes. It doesn't create an attorney-client relationship, and you shouldn't substitute this for actually getting legal advice from an attorney before you make any important decisions. So please use it for sort of like helping guide the way you're thinking about things, but maybe not making any important decisions that you should talk to your own attorney about. So with all of that out of the way, I'd be happy just to jump in. There's a number of topics that we can cover. We can talk about, raising venture capital. We can talk about sort of just corporate basics. Sorry. But what would be, I think there might be a hand or two raised already. It'd be great to start talking about what you would like to hear talk about. And I'm going to get a sip of water.
Nice meeting you, Matthew, and thanks for taking the time. We are still in stealth mode, pretty exciting company that we're building. But one of the big things for me as a founder is enabling virtual workforce, especially mothers and women. It's a product for kids that we're building. So we have 50% women workforce and their mothers. So for us, it's quite critical to be virtual and enable this workforce. So there are two questions related to that, or two challenges. One is employment contracts for a virtual workforce, and second is IP-related challenges. Nothing that we have faced yet, but likely to as we scale further. Have you had any experience or any thoughts in these two areas for virtual workforce?
Yeah, I mean, and obviously the sort of thing that a lot of companies are trying to navigate through. And there's a lot of benefits to a virtual workforce from a legal perspective. I think it raises a couple of things that are important to think about, and some that maybe they're longer term issues. So one is obviously each jurisdiction, so each country, and within the U.S., even every state has its own employment laws that apply to an employer or someone located in that state. And depending on what you're doing, you may need to register with like the relevant authorities to be conducting business in that state. And that can have a variety of reasons. There may be certain taxes that need to be withheld. There might be other sort of complications that you need to talk through. I think this is one of those things where, as a startup, oftentimes, I would look at it from a practical perspective rather than maybe sort of like what is everything that you absolutely, would want to be doing long term. So, I would focus on places where you have a large number of employees. Those are going to be like a location where you might want to think about, making sure that you're getting specific legal guidance on that, and what sort of things are enforceable versus not. One question that often comes up in the employment framing is, are these individuals going to be actual employees of the company and entitled to all of that entails, or are we looking to hire them as contractors? And that distinction varies a bit depending on what state they're located in. Some states, like California and Massachusetts, as two examples in the US, have very sort of stringent requirements about when you can designate someone a contractor versus an employee. I'm not an employment expert in those areas, but I do know that it's sort of enough that, some clients just take the view that either we're going to make those people employees, or we're going to aim to hire consultants from outside of those locations because we just don't want to have to deal with having them as employees. And that's the case across, a lot of, non-US jurisdictions as well. And every, country and region treats it differently. But I would say that typically speaking, there's a bit more flexibility at an early stage if we're talking about a small number of employees versus if you're employing a larger workforce in a particular area. And also, I think we're still in a bit of this, post-COVID world where, I think there's going to be a lot of changes, right? A lot more people are working virtually. They're working, partially or hybrid or totally virtually. And, I think there are going to be a number of sort of shifts in how that is treated from an employment perspective that haven't really settled yet. So, I think it is something that you want to monitor. But I would focus your efforts on where do you have the most people?
Thank you.
Yeah, I mean, I'm happy to talk about sort of other issues around hiring employees and compensation and things like that. We could also talk about sort of basics around just sort of corporate governance, if that's of interest, or other things to think about when operating across borders. So feel free to put topics into the chat. Maybe while people are kind of thinking through what would be helpful to them, I'll give what I would call my bottom line, startup advice from an attorney. And it sounds very basic, but I say it every time because it's probably the biggest source of where we see headaches and expenses that happen down the line. And that is, it's never too early, and it's never too, there's really no point at which it's too early to start formalizing what you do as a company and thinking about how do you want to structure things, and things like IP assignment, and making sure that each of the initial founders and employees have signed an IP assignment agreement, that that the company is going to own and control all of the IP, imposing vesting on the founders, including yourself, and imposing a reasonable vesting schedule on your stock, has significant long-term benefits, and we can talk about that a little bit as well. Having a good set of bylaws and sort of corporate processes that you follow internally, all of these are the things that are fixable down the road if you haven't done them, but they just get more expensive as time goes on, and they become more of an issue for investors. Similarly, thinking about what sort of corporate structure you want to use, where you're going to be headquartered, and what comes with that are all things to be thinking about. So there's a couple questions that I'll raise. Are there any? So I'll just read it out of the chat. Are there any standard legal requirements when a foreign company is working as a vendor to U.S. school districts, for example, in insurance? So yes, there are. So U.S. school districts, mostly speaking, are they're considered state government entities. So they're considered part of the state government in which the district is located. And so there's a number of different requirements that are typically required. It can vary depending on the state in which they're located, because that state has its own set of laws. But the main ones that I I see most frequently are having certain levels of insurance. That is a common requirement. There's usually data privacy requirements as well. So typically most will have their own data privacy agreement, or what they would call a data privacy addendum that would go to your contract with the school. And that would typically, limit the ability to use data that you collect through the agreement with the school. Typically, you're limited to using it only for, the purposes of providing the services, or maybe, some room around like, improvement of the services. It can get very much in the weeds about things like how does it apply to de-identified information and aggregated data and all of that. But typically there are, there's going to be components in your contract that deal with that. Probably the most impactful things that you could think about in the agreements as well, go to things like, some of them might have like background check requirements for individuals at your company who are going to be having access to student data, or if relevant, that would be, on site at the school. Some of them have requirements about actual data storage. So I would say this is still in the minority of cases, but there are some districts that want the data to actually be located in the US. Now, sometimes that is going to depend greatly on what the alternative is. I'll say in most cases, storage in Europe is kind of considered to be sufficient because the data protection requirements there, are generally equal to or higher than in most US places. Although, some still want data to be housed within the US. So there are sort of a significant number of requirements. There's sometimes state, what we call state procurement requirements as well. So they might ask you to, for example, go through a bid process. And if you're in part of a bid process, or if you're looking to avoid a bid process, they may ask you to certify that you're eligible under, all of their other state contracting requirements. They sometimes have limitations on, what is, acceptable from a like indemnification perspective, a limitation of liability perspective, because they're a state government. So I know this is sort of a very high level, and happy to kind of dig in on the specifics of this. But the short answer is yes, there's typically a number of requirements. They typically aren't too different for a foreign company versus a US company, although I will say most of our clients that are headquartered outside of the US that are looking to do business within the US will typically establish a subsidiary, located in probably Delaware, to actually be the one that signs those contracts. And there's some benefits to doing that as well, because one, you can silo the risk under those agreements to that subsidiary and protect things that are held at the higher level. But then, at the same time, at some point, you might want that Delaware company to become the main parent company. And I see there's actually a question about this as well, about establishing a Delaware C-Corp. I would say the most common approach that we see is that typically a Delaware C-Corp will be established at some point as a subsidiary of the foreign company, and it will hold the contracts in the US and all of that. And then, typically like at the same time as when the fundraise is going to happen, the entities will flip. Now, typically Delaware law makes that relatively easy to do. There's a decent number of variables that can come into play depending on where you're doing the flip from. In general, for European companies, it's relatively easy. There's some obviously like costs associated with it. There may be some local tax consequences for doing it as well. But typically it's not the sort of thing we generally see, clients do preemptively. And again, I'll go back to before you make any decisions on this, talk to your lawyer about your specific situation. But, in most cases, the flip of having the Delaware C-Corp will happen when you have an investor that's looking for that. And just as a kind of quick sort of recap for those who aren't familiar, you do typically see US-based investors that will insist on investing into a Delaware C-Corp. There's a number of reasons for this. One is that there's benefits from a tax perspective. There's also Delaware has a pretty favorable and also robust set of laws regarding pretty much everything from corporate governance to investor rights to all of the other protections that they want to have. And because it's so well developed, there's relative sort of clarity about how things will work out. And so, you will typically see that they'll want to invest in that. Now, that's not obviously like the only form. So part of it's going to depend on where are your investors located. You see other jurisdictions that frequently will serve as the domicile for a company, particularly if they're going to be operating outside of the US. So one of the, rationales to hold off on actually going through that flip process, one is you can defer the cost of doing it until the raise is secured, but also, if things take an unexpected turn, if your business pivots to different geographies than you initially anticipated, if you have investors that are located elsewhere or do have other requirements, you haven't gone through the process of doing all this when, maybe it wasn't necessary.
Thank you so much for the elaborated answer. Sorry, I jumped in now to face. But if you could just, I have two questions that relate to what you said. One of them is beside the investor part that you mentioned in regards to the US entity, what would be other main factors? So is it revenue in the USA or number of actual students, for example, using or districts that are using your product? And the second question is, if we talk about digital product that is mainly about content for teachers and students, so not administrative, from the point of view of liability insurance, what kind of liability risk can we expect with a digital product? And I will tell you that's very interesting. In one small district in New York State, nobody talked with us about liability, but in California, in one bigger district, this was one of the front matters that they wanted to solve. So thank you for,
So on the first question, I would generally recommend forming a subsidiary relatively early in the process of actually entering into agreements with school districts. And there's a number of reasons for that. One is it just, if you can, there may be some benefits in some states to a preference to US providers that you might be able to take advantage of if that's the case. Two, it does protect any other operations, just generally when operating a business, there's benefits to siloing your risks. So if your contracts with one type of institution, one location, let's say you're operating within the US and within Europe, being able to sort of silo those risks from each other, that they won't be as likely to have sort of spillover effects if something were to happen, is beneficial. And it's beneficial even if those sort of worst case scenarios don't happen, because it gives investors confidence that there's more protection to their investment, when they're going through the diligence process. So, a lot of this is just about making investors confident that you've thought about the structure, that you've taken, reasonable steps to sort of minimize the potential negative, things that could happen. But that, generally helps. It also, so on the question of insurance, so, obviously some companies are doing things that are going to have more of just sort of like a practical, risk of something happening that could be expensive versus another. And obviously this is when insurance is going to come in. It's going to come in when something has happened and it's significant enough that, your customers are going to want assurance that they're going to be mostly made whole. So obviously, like there's different types of insurance as well. And as a company, I mean, you should have a just sort of general liability policy. You should also have D&O coverage. That's really important for you as founders. And whenever you're bringing in someone in for your board, D&O insurance, director and officer insurance, what it does is it protects the directors and the officers of the company from personal liability risks if the company is being a target of litigation or the potential for litigation. Even if there's not actually a lawsuit, sometimes just the risk of it is enough that they are going to need to talk to an attorney, incur legal expenses, all of those things, and that's where you'll want to have insurance coverage for them for that. And then the third big bucket that you see of insurance coverage is typically you will get some specific cyber insurance, so cyber liability insurance that will protect in the instance of a data breach or a potential vulnerability that's been identified. And cyber liability insurance covers a number of different things. So typically in the event of a breach, you're going to need to do a forensics audit to make sure that you can determine what happened and take remedial steps to try to resolve the issue, make sure it doesn't happen again, or take reasonable steps to try to make sure it doesn't happen again. You might have to provide notice to impacted individuals. You might have to provide credit monitoring depending on the type of exposure that happened. And then there's going to also be just, PR, comms that you need to do. There's going to be legal expenses. So even though typically it's not like there's big, judicial, monetary, fines or awards for these things, just the expenses of having to deal with all of this can add up. And so you want to have coverage for that. Because, the other sort of, challenge with some of these things are, unless your data is being housed in separate areas, chances are in most cases, an incident that impacts one customer is going to impact multiple customers or maybe all of your customers. And so you're going to be having to deal with multiple sort of responses at the same time. But so I would recommend, I think what I would recommend is getting as much insurance coverage on all three of those points as you reasonably can. I think it's a good value to do so. And I think it provides, again, investors, particularly those who might be serving on the board and otherwise sort of confidence. If you do that, obviously you're going to be limited to what sort of policies you can reasonably get, but it's not an area that I would look to save on. I would recommend generally having, as robust of coverage as you can reasonably get.
Thank you so much.
I think the next question is about vesting, and I can talk through that. So just really sort of quickly, when we talk about vesting, we're talking about that. At what point, let's say the founder is going to be, just to make things a really simple math example, they're going to be a 50% owner of the company. So they're going to have 50% of the outstanding issued stock, right? And then there's going to be other pools that are not yet issued, and other things that will change. And over time, like you'll authorize more shares, and you'll get diluted, and you bring in investors, and you'll bring in employees, and you're going to want a stock option pool. Like all of that changes over time. But the very basics of why you would impose vesting. So vesting means that even though the employee or the founder or whoever we're imposing vesting on is entitled to that 50% of shares, they're going to invest in it over time, which means that if they left the company prior to the time in which they're fully vested, they would only get the amount of shares that they've actually vested in. And so typically, in most cases, you would have a 1-year cliff, which would mean that for the first year, there is no amount they're entitled to. So if they leave during that first year, they leave with no shares. And then typically at the end of that year, they would vest in, say, like the first third to first 25% of the total shares that they're entitled to. And then they would vest monthly after that over a 3 to 4 year period total, at which point they would then be fully vested in those shares. So it's beneficial for the company for a couple of reasons. One, if you have multiple founders and one decides to leave relatively early, you don't have to worry about having someone who isn't contributing to the development of the company, having this relatively large spot on the cap table, without having to buy them out or do anything. What happens is if it's shares that they're not invested in, it gets returned to the company when they leave. So there's benefits to it there. But even as from a purely personal, like as a founder, the reason why you would impose vesting early is because when you bring in your first round of investors, whatever you've done previously, almost certainly they're going to reimpose vesting. So they're going to say, even if you're fully vested, we're gonna want to reset the clock, and we're going to want you to vest again in that same amount. And we're going to want you to agree to do that because we want to have confidence that you're not going to take our money and then you're fully vested and you could sort of go do whatever you want, right? They want you to have an interest in sticking around after they've made that investment. And what I think we've just seen in practice is if you had previously imposed vesting prior to that point, you're not going to get credit for all of it, but you'll probably get credit for part of it, right? So maybe they'll say, we're going to do vesting over 2 years, or we're going to let you keep 50% of it and you're going to revest in the other 50% of it, or something along those lines. In most cases, if you haven't vested, they're going to make you start the clock at 0 and go from scratch. So you're just going to be 2 years, 3 years further behind in your vesting than you would have been had you imposed like a reasonable vesting schedule from the start.
Thank you. Can I have a quick follow on that, Matt, if I can?
Sure.
We're in a somewhat interesting scenario that it is a research-funded project where there's academic advisors involved, and the mechanic of it is that the academics involved will return to their full-time employment but stay on as advisors. So they'll have a minority equity stake with some kind of vesting provision put in place. In a situation like that where they haven't got day-to-day involvement, what metrics are sensible or what structure is sensible in order to understand if they're still with the business involved, as opposed to just picking up the phone and being reactive to any queries that come their way?
Right. So typically you would handle vesting differently for different categories of individuals. So the founders would be one. And then another group would be like your early stage employees, but they're full-time or roughly full-time employees that are dedicating most of their time to this endeavor. And then there's another group, typically you would call them advisors, and you'd issue them like advisory shares. And these are people who are going to be there to help advise the company, but it's not their full-time job. It's not the thing that they're doing day to day. And there's a couple of different ways that you would handle that. So oftentimes you handle that through actually granting stock options to them as advisory shares that they can, they can then purchase the options, at the right time when their time ends. There's a number of different rules about when they can do that. So you want to set up your option plan, pretty tailored to where your advisors are and otherwise. But typically you would set up some sort of metrics, at which point they would then vest based on those metrics. So, if you want them to do, if there's sort of minimum requirements that you expect them to meet, then, you could have them sort of, vest based on whether or not they've achieved those metrics. The other thing that you'll typically see is it's time-based. So typically you wouldn't have an advisory agreement that goes more than 2 years. I mean, there could be cases where you would maybe want it to be longer, but you would set it up as to be renewable. And so if you find that someone, just isn't adding the value that you expected, or maybe the value they've added has been perfectly fine, but you see that time coming to an end, it's just, they've kind of fulfilled their role. We don't want to keep them on. You can set it up that they're going to vest, an certain amount over 2 years, with the recognition that if we want them to stay around for another year or another 2 years, you as a company have the option to extend that if they agree. But it's different than if you had set it up as a 4-year advisory agreement.
Would investors, follow-on investors, do what they've done with the founders in terms of hitting reset on the clock in those scenarios?
So I can only give a lawyer's favorite answer of it depends. It would depend on a lot of factors. It would depend on how many shares in general we're talking about. It would depend on whether or not the cap table overall looks reasonable and attractive to the investors or overcrowded. It would depend on if the investors think these individuals are going to continue to add value down the road. This could be an opportunity for them to essentially cash out their options in the right cases. So there's a lot of factors that would come into play there. I would say typically it would be treated differently than the founders, who, typically at an early stage, they're going to want the founders to stick around. They might feel less strongly about certain advisors. So you could even find it could be case by case where their approach to one is going to be different than another.
Okay.
So those are the sort of discussions you have with the investor, at that early stage.
Okay, perfect. Thank you very much.
I know we're almost out of time. I see that there's a question here about, is there a comprehensive repository of legal checklists? So not necessarily a checklist, but what I can highly recommend is a plug that I had planned to do at the end of this anyway, which is for our Cooley Go microsite. It's www.cooleygo.com. And what it has there is a pretty extensive library of content regarding all of these sorts of topics and many more that we haven't talked about, really focused on, growing a company, fundraising, dealing with advisors, dealing with early stage employees, the sort of the whys and the hows, but done so in a very non-legalese, very digestible sort of way that, the most articles take, 5 to 10 minutes to read at most. And they're very approachable. And so I do recommend checking it out, just kind of scanning through it. Also on Cooley Go, we provide, I think, a great resource of sort of the latest data that we are seeing from all of the deals that we're involved in, some of which are public, some of which are proprietary. But we combine all of that to give sort of a state of the VC market. And you can break it down at different series or based on different regions. We don't break it down specifically by Edtech versus other tech deals that we're working on. They're kind of all sort of combined together, but you can see things about what we're seeing about, valuations, certain governance rights, all sorts of different trends updated quarterly. And so you can track it over time. You can track sort of where the most recent trends are. And then the third component to Cooley Go that is also good for companies operating in the US Singapore or in the UK are that we have document generators that a lot of the basic documents that we've talked about, you can put in the information yourself. Again, I still would recommend that you then show those final documents to an attorney to sign off on, but it can get you, significantly far along the way of creating these things than you would be if you were starting from scratch. So definitely, if you're operating in those locations, we don't have them for everywhere, but US and the US is our most built up repository, but we also have ones for UK and Singapore companies as well. And we're always updating the content, so it's something to definitely keep track of.
That's amazing. I'm sneaking myself onto the stage here to thank you, Matt. And I know there's a lot of useful information in that Cooley Go. So and as you said, we're running out of time. It's been a fantastic session. Great questions. Thanks to the audience and very good answers as expected, Matt.
Yeah,
So,
thanks for having me. If anyone has any questions that either you didn't want to ask in front of the group, or we just didn't have time to get to, or you didn't think of at the time, feel free to reach out. I'd be happy to have a one-on-one chat. My email is just mjohnson@cooley.com, so relatively straightforward. But feel free to reach out, and thanks for joining, and great to meet everyone.
Fantastic, Matt. Great. And thanks again, audience, for amazing questions and for your support this whole week. We're now 3 days down, 2 to go. Hopefully I'll see you tomorrow as well for the ESG impact and evidence sessions, and on Friday for fundraising and governance. So still got loads of great content coming up. Thanks everyone. Have a nice Wednesday.